Good morning. We have one more good case for defense lawyers, criminal side, and particularly you may understand several provisions when collectively offences are committed, how to frame charge, how the courts are dealing with when lot of things happen. This is case of AR 2024 Supreme Court 1080 1080. AR 2024 Supreme Court 1080. Kishore and others versus State of Punjab. The charges were 149, 148, 141, 460, 302 IPC. The lower court convicted all the accused. What is 460? 460, if anybody collectively lurk criminal trespass for committing offences, if death is caused, all of them, even though there is no specific act, all are liable to be punished. This is what 460 IPC says. But however, during appeal, the High Court has acquitted two of them. Therefore, the Supreme Court, now deeply by discussing the entire evidence, which you must go into and understand how the evidences were appreciated by the Supreme Court and how they were acquitted. Number one ground was that since two accused were acquitted by the High Court ought to have framed charges under section 34 because 141, 148, 149 is not applicable because there is no member 5 or more. But however, the Supreme Court said the court did not frame the charges for want of evidence, might have been. That's what they say. Thereafter, what happens? The Supreme Court says the witnesses did not specifically stated which accused caused which injury. Only vague statement was that injury was caused, and important two injured witnesses were not examined. And finally, the one more important aspect was that the jewels recovered, and that jewels recovery was identified by the identification period, mixed with other jewels. So the investigating officer or the prosecution failed to produce or examine the goldsmith to prove that the recovered gold jewels were mixed with other jewels from where those jewels were brought in. So this they say the role, that evidence, that recovery was also not believed. So all the accused were acquitted. Here is a case, unfortunate case, when they were sleeping. The 5 accused forcibly entered into and looted the entire jewels and caused injuries when there was resistance, and one of them died. This is the case. 2 were died. Go through the entirety of judgment, this may help you, but this is apart from this 148 deletion for lack of 2 accused who were acquitted, that is several multiple judge. But this is most important, that when the recovered material objects were mixed with other for identification, and the source of other ornaments, since not proved, the entire 27 recovery was disbelieved. I hope you understand. Best wishes.